So we have here Michael Smith, who's actually an IP lawyer or patent lawyer with Kepler Aerospace. And we're just going to take a deep dive into it and discuss theoretically and legally what is involved with this kind of science, because it's a really unique situation, right?
It is. You mentioned that the significance of these inventions is huge, okay? And one of the problems is that when it's huge, a lot of people are going to want to copy it later on, right? And so if you don't have any protection on this, you know that they're going to. They will for sure, okay? Just too much money involved, okay? Absolutely.
We were in China. Searle technology.
Right. So, yeah, that's an interesting topic you brought up, China, by the way, because, a lot of people have lost their shirt off of their inventions in China. And about 10 years, 10, 15 years ago, there was really no patent protection in China, okay? And that's actually changed quite a bit. That's a big topic in itself, but you can enforce patents in China, okay? But you still can enforce patents in the United States and Europe, okay? And I think that's really the primary focus of most people who are inventing in the U.S. is first to get patents in America and then in Europe too.
Especially if you're working for a big company, they want you to not spill beans. What I found is that back in the 90s worked better than what is claimed with the patent, which is really amazing. So, there's no barrier. You just have to, say, I don't believe it is all of this. I don't believe it's all of this. I built it and tested it to prove that adage. And why people like Tim Ventura and Tom and good friends with you can't just, because then you're missing. You've got to investigate first on a small scale and then scale it.
Did you make any improvements to the patents from Brown at all, or did you just copy what was in the patents?
We just copied straight from the patents. In the year 2000 at Jim Cox's second anti-gravity conference in Reno, Nevada, we demonstrated the T.T. Brown electrokinetic apparatus with 1 meter diameter flying saucers. And they worked great with just 100 to 120 kV at some tens of microamperes. That's not a whole heck of a lot of power, but yet they got up from a standing start and sailed around that maple.
Further.
You have to replicate these patents to either or experiments to either confirm or refute them. That's standard scientific behavior. Replicate it as exactly as closely as possible to confirm or refute the effects. And it turns out the effects are confirmed, which is really, 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 really exciting.
As a patent practitioner, I find it really interesting that you copied those patents and you just replicated them in the lab and they actually worked, because one of the requirements of patent is that the patent should have enough information to direct one of ordinary skill in the art how to make and use the invention, okay? And that can be a real big problem when people are enforcing their patents, okay? It's a basic requirement. Sometimes the patent office examiners, they kind of pass over that, okay? And people get issued patents and they're a little bit weak because they really aren't sufficiently enabled, okay? That's what we call that enablement.
Well, it's peer review. Peer review. Think of it like peer review when you're submitting a paper to a scientific journal of an experiment or a process. You have to have independent confirmation. And obviously in the Beefield-Brown devices and Searle devices, we do have that peer review and independent confirmation.
Right. Well, you did the peer review, but I guess the point I was trying to make is, when you go through the patent application process, no peer review like that is required. Okay. I mean, the examiner is supposed to apply his experience and knowledge to, read the patent and decide whether or not there is enough information to enable.
All the experience and knowledge that is congruent. The patent examiner might not have all the experience and knowledge that is congruent with that discovery or invention.
Yeah, quite often that's true. That's true. Even then, I guess I'll speak up for the examiners on that one. Quite often, they really are experts in the little the technology subfield that they're speaking in.
Tom Vallone's former job as a patent examiner in Washington, D.C. Tom Vallone was a patent examiner in Washington, D.C. So it was his job to do that very thing.
Who's Tom Vallone?
Tom Vallone.
Vallone.
Yeah, he is a free energy and anti-gravity expert in the field. You can see him on cable TV pretty much any night of the week on Ancient Aliens or some other TV programs. But I've been aware of his work since early 90s, about 1990, when he wrote the U.S. Anti-Gravity Squadron about the B-2 Spirit stealth bomber and showed that it was an anti-gravity craft using Thomas Townsend Brown's patents, most notably the electrokinetic apparatus and his patented flame jet generator that could produce potentials up to 15 million volts. And of course, when you're dealing with electrogravitics, just like you're dealing with high electrostatics, which it is, the larger the voltage, the force goes up exponentially. That's one of the most important aspects of electrostatics. Again, remember, electrostatics is only second to the strong nuclear force that holds atomic nuclei together. At that distance, they should accelerate apart at the speed of light, but they don't because of strong nuclear force, which is the strongest force in nature.
So Tom Vallone is a great example of an examiner who actually knew what he was doing. He was a real expert in his field. He
ran into problems with the patent office because of that. And he can tell you at length about that experience. I have listened to that, and it's like, I have seen this type of behavior before with academia, with government, with big business, except big business with vision and higher echelons up in the military industrial complex, where they're taught a totally different physics. We're dealing with a physics that is as clandestine as Nikola Tesla's work, which resulted in the what Tom Bearden says was the elimination of Nikola Tesla, or the attempted elimination of Nikola Tesla from the mind of man. And if you look at we had when my sister was born in '55, we got the Encyclopedia Britannica. Just as an experiment, I looked through the entire 100 volumes or 50 volumes, however many volumes of the Encyclopedia Britannica of 1955. There's plenty of mention of Einstein, plenty of mention of Newton, plenty of mention of Edison, but absolutely no mention of Nikola Tesla, which I found not only puzzling, but actually infuriating.
Well, speaking of which, I know Nikola Tesla did actually get a number of patents, and there's still 700. You're right. Yeah, that's good. You know the number, but yeah, there's. Now I do know that it is quite frequently Nikola Tesla's patents are used and cited in patent applications. Okay?
Oh yes. They're because they're fundamental. And what's really interesting about Nikola Tesla's patents is he would get waking dream visions of devices that he maybe wanted to build or maybe had never thought of in front of his field of vision, which caused him some fear and consternation. But he would build not blueprints to the consternation of his engineers. He would build right from the vision he saw in his mind. And do you know that all his patents, every single one, worked perfectly the first time, every time? Not only that, Nikola Tesla was not a fan of Einsteinian relativity. He thought it was a smokescreen. He said, of course there is an ether. There has to be. All my patents depend on its existence.
Right. So anyway, just going back to the patent examiners, you were mentioning Tom Vallone. Maybe my experience, having been a former patent examiner, is that there really is a lot of expertise in technology in the patent office. In fact, when I worked at the patent office, there was someone else in our department who had written 7 books on the topic that we examined. Wow. And of course, Einstein was a patent examiner. Tom Vallone's a great example. I didn't know about him before. So
yeah. You can read his bio online and at the Integrity Research Institute, and I've been going to the Kofi conferences since. And I've been going to his Kofi conferences since 2006, I think, or maybe earlier. I forget, but anyway, he has done a monumental job in getting the idea of this technology in our human consciousness and psyche so that we can advance and not stagnate as a culture. At this point, we need to have these technologies to generate clean, cheap energy. Of course, the devices are not cheap, but the power is going to be, like they said, nuclear power would be too cheap to meter. And also for flight, warp drive, and so that we can colonize space for the very survival of Earth humans. We need to colonize space for our very survival.
I think one particular idea that needs to be shared here is, like at TeslaTech, what we're seeing is we're seeing a lot of very innovative technology that people are working on and people are disclosing. And I can see how some of the stuff that's being discussed and disclosed here will become the basis for some really important inventions coming up in the future, which means that, we're basically sort of reinventing a lot of technologies that exist out there. And when you look at how that's going to affect society and what has happened with new technologies in the past, what we can anticipate is a lot of patent wars. This has happened in a lot of different fields historically, like in the automobile industry, aviation. It happened with cell phones here just recently, where the people, they have patents on some of the early technologies, and a lot of people are not respectful of that, and they start infringing the patents, and then the people who own the patents will end up suing them. So I think we can anticipate.
What about when a patent is too broad? Like, I know we discussed this the other day. Or is there such a thing as too broad? I know the Wright brothers got a patent on wing warping, which some people say was way too broad because that you can't build an airplane without ailerons, and that led to a massive war, a patent war that ultimately ended in World War I when the Army needed freaking airplanes, and they put them, the surviving brother and Curtis got them into an office and said this is a settlement. So like there's a legal question, there's an emotional question, and there's just what an ethical question.
There's a public policy question. Well, the term you used, overbroad, that's subjective. Okay. I mean, if you apply the law as it exists, okay, quite often you do end up with, some people end up with some very, very broad claims. And I've gotten some issuances like that myself. And that's really because no one else had come close to inventing what those particular inventors had come up with. So I don't think myself it's unfair that someone gets a patent on something as broad as wing warping. I do know that the Wright brothers, they had the opinion that their patent on wing warping included ailerons. Okay. That I wouldn't agree with. Okay. And I know they were trying to enforce their patents against Curtis Wright, because Curtis Wright was trying to get around the Wright brothers patents on wing warping. And so Curtis Wright invented the aileron. The Wright brothers did not. Okay. And so the Wright brothers were trying to enforce their patents against ailerons, which I think is incorrect to do. Okay. But nonetheless, I mean, there's a lot of public policy issues here, because when people come up with new inventions, the people who invent it, they want to be rewarded for that. Okay. And other people want to use the same ideas because they have a lot of applications for the same ideas that maybe the original inventors haven't thought of or can't get to because they don't have enough money, they don't have enough expertise. Okay, so the owners of that patent want to hold on to that real tight, and they want to prevent others from using their inventions. And it does get to be a little bit restrictive in the sense that sometimes those ideas aren't quite implemented as broadly as we would like. Okay. The way to get through that is basically licensing. Okay.
Yeah,
so
exactly. Yeah. And you license to the people on a yearly basis, and whatever company has the best performance with the invention, their licenses will be renewed.
Right. And they'll, whoever's more successful in using those inventions will pay more licensing fees to the owners, and that's what the owners want usually. But yeah, with the Wright brothers,
The inventor was an extraterrestrial, and he just came down here, and I mean, this is a very real possibility. Like,
Yeah, not only is a real possibility, but we take the accounts and experience of men like David Hamill of Canada, and his experience was documented in his book, The Granite Man and the Butterfly, where he talks about being a UFO contactee of aliens from the planet that the aliens themselves called Planet Cladden with a K, Kladen. They gave him technology, and it was working technology. So that's a prime example of what you were talking about.
okay, so as far as U.S. patent law is concerned, the inventions that are made by aliens is not prior art. Okay, so if we we could patent it here ourselves if we receive that information from aliens, extraterrestrials, we could patent it here. Okay, that's the way U.S. patent law is currently composed, because U.S. patent law hasn't considered the fact that there could be extraterrestrials, okay, in informing people. That's so it would be a great thing if extraterrestrials came here and told us how to do something, we could get the patents.
It's foreign technology. So it's like, think of it the same as if we stole classified patents from China or something, you know, like it's the same idea. It's foreign technology.
That's why all these UFOs, the crashed UFOs, were taken through Dallas Fort Worth, I think, up to Wright-Patterson's Foreign Technology Division in Ohio. And that has been documented too. So yeah, we can see that there's contamination from extraterrestrial sources that eventually filters out into our technology and society. You can look at
It's just that we just, as far as the patent law is concerned, it doesn't matter whether it's extraterrestrial or Chinese or Russian. It's foreign technology, and it just falls under that category according to patent law.
No, actually, if it's been disclosed publicly by a foreign nation, okay, and it's accessible here, that would be prior art. Okay, so we can't copy, we cannot get an invention on something that was invented by the Chinese, okay, but we could get a patent on something that was invented by extraterrestrials. Okay, so
there is a distinction.
in the book, the day after Roswell, if you've seen that book, the guy talks about he was in the army and he was privy to all these UFO crashes, and it was his job to slowly disseminate the technology like printed circuits, fiber optics, and integrated circuits into our society. Lasers, they all came from right here in New Mexico in the 40s, late 40s.
yeah, I think you're talking about the guy from the CIA. Yeah, Philip J. Corso. Yes, for the Pentagon, right? The day after Roswell. That was actually a fundamental book that got me on the road to flying saucers and where we are today. Another point is, like, if an alien landed and handed you all this technology, you're saying it's not prior art. It wouldn't be. Okay. Is that because they didn't think of this eventuality, or does it say it specifically that that is not prior art?
No. I mean, the patent statute does not recognize prior art that's outside of Earth. Okay, so it just doesn't recognize it. It just.
Do you see the potential for this going to the Supreme Court? I mean, the patent law obviously should have been updated. Right?
Yeah. Well, probably. Yeah. I mean, I think that could go to the Supreme Court, because if there were other parties on Earth that were using the same invention and they didn't have a patent for it, okay, they would probably feel a lot of compulsion to challenge the validity of the patent that the other person on Earth got, okay, and saying, well, there was the prior art is from outside Earth, and that should be recognized. Okay, I can see that happening very much. So that would be a great court case. I hope I'm the guy to do it too.
You're probably the first one to talk about it.
Well, I guess now that the government's disclosed, the existence of things we can't identify, maybe they should consider updating the laws.
well, they should, but you know, I gotta tell you, you know, they can't get anything done. Okay, so and don't expect a whole lot out of Congress on, especially on some big thinking thing like that. Okay, so
It took him how long? 90 days to write 6 pages? A 1 page?
yeah.
It was that report.
Well, would it be helpful just to have a basic rundown on, you know, what's patentable? Just, you know, kind of what are the basic rules of patentability? Okay, so the basic rules are that a patent needs to describe to one of ordinary skill how to make or use the invention. So there has to be enough information, as Tom Vallone, you were telling us, did have in his patents. So that's one of the basic requirements. The claims in a patent to be issued have to be new, useful, and non-obvious. Okay, this is just really basic patent law that I'm sure a lot of people listening to us have already heard. Okay, so basically new means that there is not a single publication, such as a patent or a technical journal, that describes everything in that particular claim. It needs to be useful, which means that the claim actually has to describe something that actually works. Okay, and it has to be non-obvious, which means that there are not 2 or more references that can be combined that in together describe the claim that's that issue. So it's every claim needs to be new, useful, and non-obvious. Okay, so one of the really big issues in patent law in the last few years has been enablement. You know, that the patent describes to one of ordinary skill in the art how to make or use the invention. Courts have been getting rather strict about that. Okay, they've been expecting and demanding a lot of detail in patents. Okay, and I kind of saw this coming a few years ago. I think all good patent attorneys are writing patent applications that have a lot of detail in them. Okay, at this point, you know, you really, my opinion is that you just can't have enough detail in a patent application. You really need to put a lot of detail in your patents. Patents 20 years ago, most patent attorneys weren't thinking about putting a lot of detail in their patent applications. Okay, those patents, when they're enforced and they go to court, are getting knocked out. They're becoming invalidated. Okay, so
It's the lack of detail.
Lack of detail. You know, a patent attorney calls that enablement. Okay,
Yeah.
So
Or else argue legally the specifics of the case because there's not enough detail to say, oh, well, this is covered by your patent and it is protected.
Well, there isn't enough detail that one of ordinary skill in the art can make or use the invention. That's kind of how, those are the buzzwords. Okay, those are the magic words we use. Okay.
17 years.
Well, actually, 17 years is the rule before. The rule now is 20 years after the priority date. The new rule on the term of a patent is 20 years after the filing date. Okay, so if it takes you 4 years to go through prosecution to get an issued patent, you would have 16 years of term left in which you could enforce a patent, and any infringement that happened before the issuance is not an infringement. So
I can think of several issues with those statements in terms of extraterrestrials. First of all, the invention, no, it is prior art. That will probably go to the Supreme Court. That'll be a very interesting case. Another thing is I'm thinking about all Steve Ellswick's VHSs, because like those will come, that will be a great discovery in terms of whether it was talked about in a publication. Is TeslaTech considered a publication? I'm sure anything you can dream of has already been talked about here.
Extraordinary Science and Technology, the magazine's a publication, but what was really exciting for us after we had applied for the patent several years ago was that the patent examiner had actually allowed 32 of the 37 patent claims. And at that point, I knew that the patent would be granted, which was really exciting. It took a few years. It took some years, but the patent for the Searle spintronic generator was eventually granted in January 16th of 2018. So Professor Searle got to live to see his work actually patented. He was given bad advice before. The advice was, you don't want to patent it because it's a know-how, you know, but that was wrong. That scared away a lot of investors. Now that we have the patent, investors should be coming out of the woodwork.
Was Professor Searle, was he advised that he should keep the invention as a trade secret? Is that the issue?
Yeah.
Well, that's not unrealistic. I mean, if Professor Searle could have kept that information secret, okay, and set up a trade secret program,
Process secret, yeah.
right? I mean, that's not a bad way to go. I mean, it really isn't. Okay.
Right.
The problem is, if someone else invents that independently without accessing any confidential information, they are allowed to use that invention. Okay.
Wow.
So
Also-
that's not stealing. That is not stealing.
No, also the patent laws changed several years ago, so we had to hurry up and get the patent app in because it's no longer who came up with the idea or invention first, it's whoever files first. So it could be filed by the company secretary and granted to the company
Well,
secretary.
you're right. We do have a first file system that was passed in law in 2011. It's fully implemented by March of 2013. Okay.
Exactly.
So speaking of which, I've noticed a problem here at TeslaTech, okay, because people are disclosing their inventions, okay, to other people who understand the inventions. And quite honestly, anyone who has heard these disclosures, for any disclosures that have not been patented by the presenters, the people in the audience who have heard this could rush to the patent office
Oh, yeah.
and beat them out, and they can get the patent because it is a first to file system. We used to have a first to invent system. So I have wondered if there isn't a problem here at TeslaTech
Why they ever changed it? What went through their minds to
Oh.
make them decide to, what went through their minds of the patent office to make them decide to change the patent laws to first to file?
Well, that's a really good question. I mean, a lot of people have a lot of different theories. Okay, I mean, it was explained to us in a professional manner that we were harmonizing our law with other nations. We were the second to the last holdout of nations that still followed a first to invent system. Okay, and the idea is we're trying to harmonize our laws to the patent laws of other nations. Okay, who use a first to file system. Okay. But a lot of other people feel a little bit suspicious about that because you see, the problem is when you have a first to file system, what you don't have is a first to invent system. So what that means is when you get into patent prosecution, if someone is using, if the examiner is using prior art that was within the last year, what we used to be able to do under our first to invent system is we used to file declarations called swear behind affidavit, okay, where the inventor says, I actually did invent this before the filing of this other person's patent, okay, that's being used against me, and then that reference was removed against them, okay, it was taken out of the record because the inventor had sworn behind it, okay. So a lot of people feel like the law was changed so that basically people's inventions can be stolen from them, to put it bluntly, okay. So
the law. I heard. I have a friend who actually is a patent attorney, and we had this discussion about the first to file thing as well. And he seemed to think that the reason for it was that the patent office was getting too bogged down with legal cases for arguing, and that they didn't want to deal with so many cases, so they just changed it to first to file, so that it's just like, all right, well, it's the paperwork's in, and that's it. And so it can't be like, because there's too many cases where it's like, well, I thought of that first, and here's my, it's,
Yeah. How do you prove you thought of it first? How do you prove you thought of it first? That's the problem with that new law.
with the new law, that's the problem with the way the law used to be. Okay, so the problem with the law now is that you don't even have a chance to prove you were first to invent. I mean, the problem is before you would have to prove that you invented first, and there's a lot of evidentiary issues there. Okay, and when you were talking about your patent attorney friend who was saying that the examiners were bogged down. I mean, it didn't happen that much. I mean, I'd have to disagree with that. I don't think it happened that much that people were swearing behind references in prosecution. Okay, I don't think it happened that much. I did do it myself a few times with inventors. We had prior art that had a real close filing date to ours. Okay, but even then, I got to tell you, it was very clear that the examiners really did not want to have the affidavits showing a swearing behind. Okay, first to invent. Okay, they used to find all kinds of reasons to throw out the affidavits and say that we're not even going to accept your affidavit, and therefore we don't recognize that you were the first to invent. That was happening a lot before that law came through. So, but anyway, just to reiterate the point that you know, if people are making, if they're at conferences like TeslaTech and they're disclosing their inventions and they didn't file a patent on it, someone else can beat them to the patent office and patent it right from underneath them. And as odd as it sounds, then the person who is at TeslaTech and disclosed their invention would actually be liable for damages for infringement to the one who copied their idea and beat him to the patent office. Yeah, I know.
The conundrum.
Well, I think the law change is a big problem. Okay, I mean, I never liked the law change.
That's why we raced. The new law is a huge problem. That's why we raced to get that patent application in before somebody else did, to protect Professor Searle's rights.
You did that just recently?
Yes, it was, the patent was applied for in 2013 and granted, of course, in January of 2018.
Okay, it took 5 years to get through the patent office, huh?
Yeah, it took that long. But as soon as I heard that 32 of the 37 patent claims had been allowed by the patent examiners, I was like, oh, we're in like Flint. It's going to be granted. And of course it was.
Yeah, that's good news. You know, a 5-year prosecution is actually longer than normal. They had a bigger backlog back in 2013. Okay.
No. It's because of the nature of the invention. When you have all these claims of anomalously derived energy with no discernible source that's conventionally acceptable, and performance that is really high coefficient of performance. So they examined the heck out of it before they granted it. Same thing with Thomas Townsend Brown's patents. They were filed in the late 1950s, but a lot of them took 3 or 4 years to be granted.
Yeah, you know, I gotta tell you, just hearing about that technology on the face of it, it really does sound like the kind of invention that the patent office would not want to issue a patent on, and that they would seriously question us. So I'm not surprised at all. It took 5 years.
Which is why Tom Vallone had a falling out with the patent office.
Oh, I'm sure. So, yeah. Okay. Any other IP topics? I mean, maybe I could just, if are trade secret programs of interest to anyone here? I mean, because you know the problem with a patent, by the way, is you have to disclose to one of ordinary skill in the art how to make or use your invention. So you're basically giving a roadmap if you follow the rules. Okay, so a lot of times people don't want to do that. They want to keep it secret. Okay, if you really can keep it secret, okay, trade secret programs aren't a bad way to go. Of course, like I said before, you know, the problem is if someone else comes out and invents that independently on their own, they have not stolen the trade secret, okay, and they are allowed to use the invention, and they can even get a patent on it, okay, so they can patent it out from underneath you, okay.
Exactly.
But so there's a weakness there. And there's also the weakness that you do have to set up a very formal trade secret program. Okay, it's a set of procedures that your company adopts and that you follow by the book. Okay, and one of the big problems with trade secret programs is the program itself does not get examined or approved by the government ahead of time. You set it up on your own, okay, and if you set it up wrong and then you end up in litigation when you're trying to show that someone stole your trade secret, which is called misappropriation trade secret, then the court will examine your trade secret program at that time to decide if you had a good trade secret program, and they will also look to determine whether or not you actually followed the trade secret program too. Okay, so the point is, if you've made mistakes in setting up a trade secret program and following it, by the time you get to court, it's just too late. You know, you can't go back and change history. Okay, and if the court doesn't like what you did with the trade secret program in those 2 areas, you're dead. Okay, yeah. So the nice thing about patents is we have an examination process. Okay, so an issued patent does have a preponderance of it has a presumption of validity. Okay, it is a rebuttable presumption. Okay, so you can get knocked out in court, but it's a good first step. You know, the examination process is a pretty good step in getting some sort of you know, verification and validity that you really do have a valid patent. And a lot of people, they don't have complete confidence that the examiners have done a completely thorough job. Okay, so they will take extra steps themselves to make sure that the patent is strong and valid. Okay, there are the things that they can do. It costs more money. Okay, but there are things you can do to give yourself some confirmation and a sense of confidence that your patents are good. So
First thing first, hire a first-rate legal team.
there you go.
So I had a question about some of this and incomplete patents and all that. Those Salvatore Pais patents that were the U.S. Navy patents. So there's some speculation or rumor that those were granted because of warnings of similar advances in Chinese technology. But also there's some speculation that parts of those patents were, either changed or removed intentionally to make it harder for people to replicate that technology, that certain things have been changed around even though the patents were granted, like
one of the main reasons, actually, if not the main reason, that the Pais patents, which are very, very similar to the Searle patents, and they're multimedia craft, anti-gravitational, warp drive, all that stuff. The main reason apparently that they were finally patented was because they had a word from high Pentagon officials that they were, quote unquote, operational.
That who was operational? The Chinese?
The patents were operational already.
That they were using them?
Yes, not the Chinese.
The Navy was using them.
DOD.
The DOD, someone in the DOD is using them.
High up in the DOD, probably since they're Navy patents, it's not widely known that the U.S. Department of Naval Intelligence, was the company or agency that signed Bob Lazar's W-2 form, his tax form, and that the government agency that has the aegis over all UFO hardware and data is the U.S. Navy.
On that note, the Department of U.S. Naval Intelligence was closed in 1945, right after World War II, and it was replaced with the Office of Naval Intelligence, or the ONI.
Yeah.
But on Bob Lazar's W-2, which was issued in 1989, it's clearly states the Department of Naval Intelligence. So that's been one point that debunkers have used to say that it's not a real agency, because that department was closed after World War II and replaced with the ONI.
Maybe the department wasn't closed after all. Maybe that was just disinformation to throw off throw people off the scent.
You never know.
There's two departments or two offices of naval, or two separate, so that would suggest that there's another separate compartmentalized, office or the thing of the naval intelligence. But is there any actual evidence of that? Because I found lots of evidence of fraud in the Lazar case as well.
Lots and lots of circumstantial evidence. I say to people, and when they ask me, where do UFOs come from? I say there are two sources of UFOs. One is earthly, the other is unearthly, but they all operate pretty much on similar principles.
Well, I wasn't aware that the pay patents were actually issued because of directives from high above saying that they were operational and they're actually using the inventions.
That's
which is
all online.
Okay, I hadn't come across that, but I actually have read the opinion by others that the pay patents are actually invalid because they lack utility, which means they don't describe the invention in a way that it actually works. Okay, that they don't describe a working implementation. There's something incorrect in the theory in those patents. From a physics standpoint, that is wrong. Okay, now I mean, I'm not a physicist, okay, so I can't begin to comment, but
as a patent attorney, even if your physics are incomplete or wrong, you could still get granted the patent, even if it is a device that completely doesn't work.
Even if it works, you can be denied the patent. Look at Joe Newman for a perfect example of that. Joe Newman's energy machine waged a war since the since the late 1970s for granting him his patent, which the patent office said, nope, it's an impossible perpetual motion machine, even though it works, and it works extremely well.
John Newman. How do you spell that? Joe Newman.
WMAN. Joe Newman. Look for the energy machine of Joe Newman on YouTube and also online. You'll see it. There were cover articles. I remember seeing Joe Newman's energy machine I first saw it on the CBS News with Dan Rather when I was in college in 1982. And that clip also is on YouTube. You can find it.
Okay, well, let me ask you, I mean, would you agree that Joe Newman's invention is sort of a perpetual motion machine. Would you agree with that?
No, I would not. I would not agree with that any more than the Searle effect machine was called a perpetual motion machine incorrectly. No, 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 no. If you have, let's say, a water wheel in a stream, that could be thought of a perpetual motion machine. But think of the Searle effect devices, similar devices in that class, as being a magnetic water wheel, just operating on the seas of magnetic energy which surround us.
Okay, so we agree that perpetual motion machines are impossible. Okay.
No, 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 no. They are possible, but the nomenclature is wrong. In other words, they're coherent and congruent with all physical laws, but the effects that are seen seem like perpetual motion. They're not any more perpetual motion than the perpetual motion of electrons around a nucleus. If anybody knows any way to make that stop, please seek me out and let me know what's going on.
Okay. Well, it sounds to me like that's a really interesting topic. And I wish we could go through this in detail, to tell you the truth, because I'm not quite following myself exactly how these inventions work. And
You will.
Okay.
Just keep looking. Just keep looking online. The research today is all online. Thank God for the internet.
Yeah. Okay.
A lot of things are evaluated on an individual basis by the patent. Every patent's evaluated on an individual basis by the patent office. But I've heard that the U.S. Patent Office takes a certain stance towards, things that are interpreted to be, perpetual motion machines or free energy and stuff like that.
It's actually by statute. Yeah. I mean, if your patent application is characterized as describing an invention that is a perpetual motion machine, you're absolutely dead in the water. Okay. I mean, you get about the fastest rejection you can ever imagine. Okay.
In the patent application, we studiously avoided the moniker perpetual motion. We say this is tapping fields of energy that is all around us. It's a Maxwell's demon, a zero-point energy tapper cohering the zero-point energy, which has been basically stated by conventional physics, Wheeler and other physicists, that 1 cup of vacuum has enough potential energy to boil off all the Earth's oceans.
So did those patent applications actually recite 0-point energy in them?
No, actually they cited newer discoveries and papers by universities on spintronics and other effects. And as soon as we found out that the patent office would allow 32 of the 37 patent claims, I'm like, we're in like Flint. It's going to be granted, which it was.
Yeah. Okay. Well, that's fascinating. It really is. So yeah, I'm glad he got through that.
We just avoided all the pitfalls and minefields which have plagued earlier efforts, and we use those efforts as cautionary tales of what not to say and what not to do.
Well, that's a really good point, because when you're writing a patent, I mean, it's important to keep in mind what you need to say and to avoid the landmines of what you don't want to say. If you have words like, perpetual motion machine, as soon as free energy, something like that, the examiner sees that, you just made his day because you gave him a fantastic excuse to just reject your patent application right then and there.
No.
So
we worded it in such a way that we worded the patent in such a way that it would be congruent with the papers that were coming out or already existed in academia. So it could be confirmed.
Excellent.
Peer review, basically.
Good case study. Good case study on how to do patents for very sophisticated technology that can be controversial. And that, quite honestly, a lot of people, including examiners, okay, are not necessarily going to take a positive approach to. Okay, they could get rejected quite easily.
Well, a lot of the data and experience on these devices is very, very esoteric. It's not taught in our institution of learning, except at the very, 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 very highest levels of physics.
Yeah, I think a lot of inventors in this field have problems with that. I mean, it's with everyone. It's not just patent examiners, with investors, potential customers, friends and family. So, yeah.
Very cool. Any more thoughts on this? The Sal Pays patents, or just I'm so curious about how those got past, and there's Sal Pays is another inventor who's done another number of inventions. This guy James St. Clair, he had those TR3B patents with the triangular shaped flying craft and everything. And he had some other patents on walking devices to help you walk through walls and stuff like that. So it sounds like completely impractical. Yet here's the patent. And, well, that's a Google patent. But is there a difference between Google patents and U.S. patents?
No. Google patents are just a source. They're just a library of patents, basically.
So Google's the search engine in the library, but they're all U.S. patents. Yeah, or just
I saw some really cool anti-gravity patents by Marcel Page and Petit Vuitton, French anti-gravity experts, which many people have not heard of, but a lot of the effects. Yeah, Marcel, Marcel, Page, Pages, and Petit Vuitton, Petitviton. Now, look up those names and you will be amazed, because it dovetails with T. Townsend Brown's research, Otis T. Carr's, of course, the Searle patents, and Otis T. Carr patented his device, but only as an amusement device would they allow the patent, not as a something that people could use to fly around. Exactly.
Yeah, so they the Otis Carr patents is like a carnival ride. It's literally what it says it is. But what do you think about the similarities between the Otis Carr's XTC1 in the late 1950s, early 60s, OTCX1? What do you think about the similarities between that and also the Billy Meyer craft, and which was from the the 60s and 70s later on? And then, of course, the Lazar Sport model looks almost identical to that same shape and model. Do you think it has to do with the physics, or do you think there's some copycat kind of like behavior going on?
No, it's strictly the physics. Form follows function. If you wanted to do build a device that does all these things, that lifts off vertical takeoff and landing, that can fly at any speed with no sonic boom, fly at any speed pretty much in outer space and in the atmosphere, you have to have a certain shape. And we see those certain shapes again and again and again, whether they're earthly or unearthly. And yes, I do support Billy Meyer's accounts, a UFO case that started in 1942 when Billy Meyer was 5 years old, and is still going on today. The contacts are still going on today.
Interesting. So what was I going to say? I wanted to know about I want to switch gears a little bit, maybe if we're done with the discussion on the patents and stuff and patent law. Unless anyone else has any questions out there, I'd be happy to ask. So if you have any additional questions on patents or anything, please raise your hand in the Zoom meeting, or type them in all caps in the live chat on there. Otherwise, I'd like to talk. We got Kepler Aerospace here. I've talked to your team a little bit. Maybe we could bring Tony over here and. If did he just leave? I think he's coming back, but I wanted to get Tony on and talk to some.
Do you mind if I cut out?
Yeah, no, you want to cut out? Yeah, thank you for joining us, man. It's been my pleasure as well.
I had to go shut down my booth before they close the doors.
Absolutely, man.
Unplug the demo and all.
Thank you so much, Russell, for joining us. It's been a pleasure to finally meet you and talk to you. And
thank you. That's very kind of you. Thank you. It's education is our business, and we're trying to accomplish a change of mass mind on a mass scale for all Earth humans, so we can advance to the stars, so we can survive and thrive.
And again, we don't always have to agree with each other about everything all the time, as long as we're working together towards the same goals. That's the important part here. So thank you, Russell Anderson. And so why don't we, since we're waiting on the Kepler Aerospace guys, are they coming on to get an update from them? If not, we can move to our next guest. I don't know where Tony went, so.
Let's bring in Paul for.
Yeah, we'll bring in Paul next. See until and then we'll get the Kepler guys back on once Tony gets back here. Maybe you can get some of the other people from your team too. So if you guys want to jump on a stream and do, ask them if they want to do that, because we're gonna be live on this conference for a little bit. So